It seemed that nothing could touch New York Governor Andrew Cuomo after helping the state battle back against its high COVID-19 infection rates. He even wrote a book about it. But then Governor Cuomo had to face allegations related to two separate scandals, each of which might have been enough to topple a governor who wasn't receiving such stellar approval ratings. At this point, multiple people have come forward accusing Governor Cuomo of multiple acts of sexual harassment, and many are accusing the governor of having perpetrated a policy that has led to the deaths of thousands of nursing home residents. What are these allegations, and is Governor Cuomo in legal hot water? Sponsored by Ting Mobile. So the first scandal plaguing Andrew Cuomo involves sexual harassment. So far, 7 women have accused the governor of sexual harassment of various kinds. And in response, Cuomo has dished out the sexual harassment defense combo plate, a heaping tablespoon of I didn't do it, a side of cancel culture, and an extra helping of I know now that times have changed and these interactions are no longer appropriate.
I understand that sensitivities have changed and behavior has changed. And I get it, and I'm going to learn from it.
Governor, it's 2021. Sexual harassment has been an issue for a very long time, and you're claiming that you didn't realize that times have changed until this year? That in and of itself is a problem, especially because less than 2 years ago, Cuomo criticized the legal standard for sexual harassment in a highly informed way.
The current law says sexual harassment has to be severe or pervasive. Severe or pervasive. Look at those words. It has to be severe to break the law. It has to be pervasive. And when you look at the case law on that threshold, you have some despicable acts that have been performed repeatedly where the court has determined they're not severe enough or they're not pervasive enough. They are only sporadic, the court said. And sporadic is not pervasive. Oh, so I can sporadically sexually harass someone as long as I don't go so far as it becomes pervasive.
So it sounds like Governor Cuomo was very familiar with modern sexual harassment law. But since he's now very curious about the state of the law, what is the legal standard for sexual harassment? And what is the distinction between acts that are sporadic and behavior that is legally pervasive? Well, we start with the definition of sexual harassment. Sexual harassment is a form of sex discrimination that violates Title VII of the Civil Rights Act of 1964. We generally use the term sexual harassment to describe a wide range of workplace conduct. But for sexual harassment to actually be actionable in court, it must satisfy a legal standard. Sexual harassment can consist of unwanted sexual advances or other unwelcome conduct that is motivated by the victim's gender. This conduct can result in a tangible personal action like a demotion, or is so severe or pervasive as to alter the terms and conditions of employment. Now, who can be a victim of sexual discrimination? Really, anyone. The perpetrator may be of the same or opposite sex, or may be a supervisor, a coworker, or even a non-employee. And when the harasser is the boss, courts can generally perceive the situation to be more severe. Now, there are generally 2 kinds of sexual harassment. The first type is often referred to as quid pro quo harassment. Quid pro quo harassment occurs when a person, most often the supervisor, asks an employee to perform some sort of sexual favor in exchange for benefits, like a raise or promotion. And this is also a threat scenario where a supervisor pressures a subordinate to do something that they want or suffer an adverse consequence, like termination, or provide some benefit for taking the action that they wouldn't otherwise take. Now, the second type of sexual harassment is called a hostile work environment. And a hostile work environment is one in which, quote, discriminatory intimidation, ridicule, and insult is sufficiently severe or pervasive as to alter the conditions of a victim's employment. So let's talk about that severe and pervasive standard. In Harris versus Forklift Systems, the Supreme Court said that determining whether a workplace is sufficiently toxic, quote, is not, and by its nature cannot be, a mathematically precise test. And the court set forth a number of factors that courts have to consider when evaluating whether conduct is severe and pervasive enough to create a hostile work environment, such as how frequent is the discriminatory conduct, how severe is it physically threatening, is the conduct humiliating, does the behavior interfere with an employee's work performance, is the employee complaining of isolated comments? And this isn't a mathematical test. There is a true controversy over the ways courts apply Title VII severe and pervasive standard.
Oh, so I can sporadically sexually harass someone as long as I don't go so far as it becomes pervasive.
Well, yeah, that is possible. So let's talk about the allegations against Governor Cuomo himself. Cuomo had a lot to say about how the legal standard hurt sexual harassment victims, but what do the women who worked for Cuomo have to say about his particular conduct? Charlotte Bennett, a 25-year-old former aide to the governor, said he hit on her several times. He asked her questions, including whether she had, quote, ever been with an older man, and whether she was monogamous in her relationships. Cuomo knew Bennett had been the victim of sexual abuse and once asked her if she, quote, had trouble enjoying being with someone because of her trauma. Cuomo didn't dispute Bennett's allegations, explaining instead that he had never intended to offend anyone. Quote, at work sometimes I think I am being playful and make jokes that I think are funny. I do on occasion tease people in what I think is a good-natured way. But let's use some common sense. If the boss asks somebody how their history of abuse impacts their sex life, does that really truly fit the "it was just a joke" defense? It depends on how a jury would view these circumstances, but it doesn't seem like a jokey conversation, or at least not one that should be tolerated in this day and age. Now, the Supreme Court's severe and pervasive standard was meant to, quote, filter out complaints attacking the ordinary tribulations of the workplace, such as the sporadic use of abusive language, gender-related jokes, and occasional teasing. A few stray remarks often may make work uncomfortable, but they don't automatically make the work environment hostile in the legal sense. But the other allegations against Cuomo go even further. Other victims say that Cuomo was not just a talker, he was also a toucher. An anonymous former aide says that Cuomo groped her. Cuomo allegedly called the woman to the governor's mansion under the guise of needing help with his cell phone. According to a police report, quote, they were alone in Cuomo's private residence on the second floor of the mansion when he closed the door and allegedly reached under her blouse and began to fondle her. The woman came forward after people noticed that she was crying while watching Cuomo deny other allegations of sexual harassment against him. Another former Cuomo aide, Lindsey Boylan, said that Cuomo once kissed her without her consent and suggested they play strip poker. Boylan says that Cuomo told her he had a crush on her and started calling her by the name of his ex-girlfriend, and apparently his actions may have escalated over time.
I am embarrassed by it.
Other women allegedly had the same experience as Boylan. Another former Cuomo staffer, Anna Liss, told the Wall Street Journal that Cuomo started out by asking her about her love life and calling her sweetheart, which escalated to touching her back, kissing her hand. Eventually, he called her Sparky, Blondie, sweetheart, and honey. Now, when you combine unwanted touching and unwanted advances and comments, you're probably in the ballpark of a legally actionable claim for a hostile work environment under Title VII. Now, presumably, Cuomo will still claim that these were allegations from different people at different times, and no one filed a formal complaint against him, and all of these things even taken together don't rise to the severe and pervasive standard to make a hostile work environment claim under sexual harassment law. And some of these things are, in fact, valid defenses under Title VII. But perhaps not all of it. Which takes us to the New York Human Rights Act, because Title VII is a federal law, and it's not the only law that's at issue when you're talking about sexual harassment. What about New York law? In what may be a delicious irony, Andrew Cuomo is actually responsible for changing the way that New York interprets the severe and pervasive standard, which should actually make it easier for his potential victims to sue. New York was actually one of the first states to decide that the severe and pervasive standard let too many people get away with offensive workplace behavior. Previously, New York state law mirrored Title VII and required an employee to show that the alleged harassment was severe and pervasive in order to state an actionable claim against an employer. But in 2019, New York amended its Human Rights Act to eliminate the severe and pervasive standard entirely. Under the act, an employee only has to show that the alleged harassment or retaliation rises above the level of petty slights and trivial inconveniences. The new law also removes one of the key defenses used by employers, that the employee never use the employer's internal complaint procedure. There's also a new 3-year statute of limitations. So if Cuomo did indeed harass anyone over the last 3 years, they have a clear path to sue under New York law. So congratulations, Governor, you played yourself. You did the right thing and immediately followed that up, potentially, allegedly, by doing the wrong thing. Now, what this means for his political career is uncertain. New York Attorney General Letitia James has appointed an independent investigator to look into these claims, and many of the prominent Democrats and Republicans in New York have called on the governor to resign. The governor has often dismissed this as cancel culture, but if indeed these allegations are true, this isn't cancellation, it's just consequences. Which takes us to the second scandal that Cuomo is facing related to nursing homes and COVID patients. Cuomo's second scandal started with a dispute over how the state of New York handled COVID patients in nursing homes between March 25th and May 10th in 2020. Early in the pandemic, on March 25th, Cuomo's state health department ordered nursing homes to accept recovering COVID-19 patients from hospitals. The directive said that if a nursing home resident had been hospitalized and was stable enough to be discharged, the nursing facility needed to readmit them. Cuomo rescinded the order on May 10th. But what's the problem here? Well, on March 23rd, just before Cuomo's March 25th order, the federal government issued guidance on how to handle COVID-19 in nursing homes. Not surprisingly, the guidance boiled down to this: a patient must be medically ready for discharge to a long-term care facility, and the facility must be capable of caring for patients recovering from COVID-19. If either of those conditions could not be met, the facility should not admit the person because they could spread COVID-19 throughout the entire nursing home. Now, the first area of dispute here is whether the State Department of Health's order conflicted with the federal government's guidance. Cuomo says it did not. The New York Health Department's order requires a doctor to confirm a resident is medically stable for a return. The order also says staff must conform to New York's requirements on environmental cleaning and PPE. On the other hand, it clearly urges nursing homes to readmit COVID-19 patients. Quote, "No resident shall be denied readmission or admission to the NH nursing home solely based on a confirmed or suspected diagnosis of COVID-19. NHs are prohibited from requiring a hospitalized resident who is determined medically stable to be tested for COVID-19 prior to admission or readmission." That's pretty strong language, and it precluded nursing homes from doing testing as a basis for denying a patient readmission. New York's logic was that removing recovering patients would free up hospital capacity, which was thought to be in dwindling supply, and at one point was at almost full capacity. However, we now know that this could have been a dangerous move. Recovering patients still shed the virus, creating a strong possibility that they could infect other people in the nursing homes if they were not properly quarantined. And the people in nursing homes tend to be over the age of 70, the very age group that is most at risk of death from COVID-19. Cuomo claims that he followed the Trump administration's guidelines on nursing homes, but after the March 25th order, there was immediate pushback by various advocacy groups who felt that Cuomo was mandating that nursing homes admit COVID-19 positive people, regardless of whether they could meet safety standards. Cuomo himself publicly pressured facilities to find space for COVID patients.
They don't have the right to object,
he said on April 23rd. And yet, Cuomo's further comments on that day actually did track the federal guidelines.
If you can't provide adequate care, you can't have the patient in your facility. And that's your basic fiduciary obligation, I would say ethical obligation, and it's also your legal obligation. If you can't provide adequate care, the person must be transferred. If you have COVID people, they have to be quarantined, they have to have separate staff. That's the rule. If you can't do it, we'll put them in a facility that can do it. That's the rule.
So that's the underlying issue, but there's also an undercounting and potential underreporting issue regarding the data related to nursing home deaths. Now, the second scandal also involved how the state calculated and reported nursing home deaths. In particular, when a nursing home resident who contracted COVID-19 died after being transported to a hospital for treatment, the person wasn't included as a, quote, nursing home death in New York. This wasn't immediately apparent from the numbers and explanation the state officials were releasing to the press. Eventually, by May, though, the state confirmed that it did not include these deaths in its count. And while the legislature and media were asking about the correct numbers, Cuomo was enjoying great national popularity for his televised COVID-19 briefings and promoting his book, American Crisis: Leadership Lessons from the COVID-19 Pandemic. And Cuomo was well on his way to America's governor status, just like Rudy Giuliani had once been considered America's mayor. And like Rudy, Cuomo had high approval ratings that led many to speculate that he would one day become president. And what happened next? Well, as Rudy knows, pride goeth before the fall. By fall, Trump's Justice Department was on the case. An assistant AG sent Cuomo a request for complete data on all public and private nursing home facilities. Cuomo claimed he was being harassed by the Trump administration, but it wasn't just the Trump Justice Department. A patient advocacy group did a FOIA request for nursing home data, and of course, he was still tangling with the legislature over the numbers. And at the same time, Cuomo tried to stonewall everyone. But in January, Cuomo's own Attorney General, Letitia James, issued a scathing report on the matter. Quote, "This preliminary data for these 62 facilities and the time periods noted above suggest that COVID-19 resident deaths associated with nursing homes in New York State appear to be undercounted by DOH by approximately 50%. The health department quickly revised the death report, showing an additional 3,829 deaths of nursing home residents. Governor Cuomo and Michigan Governor Whitman issued a joint statement complaining that they were facing scrutiny from a Trump administration that was hell-bent on revenge. The former president apparently hated both of these public officials who clashed with him often. But here's the thing, you can't complain that there's a political witch hunt if you actually did something wrong. And it's probably fair to say that it should not have taken 9 months for the state to be upfront about these particular numbers. Based on the facts we have now, it looks like not all of Cuomo's actions were on the level, but the question is, did Governor Cuomo violate any law? Obviously, governors receive wide latitude in terms of the policy decisions that they have to make. Well, when the Trump Justice Department sought data on the nursing home matters, it cited its power under the Civil Rights of Institutionalized Persons Act. The CREPA authorizes the U.S. Attorney General to investigate conditions of confinement at state and local government institutions, such as prisons, jail, juvenile correction facilities, and publicly operated nursing homes. Now, CREPA only applies to public facilities, which only account for about 5% of the state's nursing homes. But the Attorney General can investigate widespread deficiencies that seriously jeopardize the health and safety of public nursing home residents. However, the government does not have authority under CREPA to investigate isolated incidents or to represent individuals. For the Attorney General to sue, there has to be a reasonable cause to believe that the nursing home conditions are, quote, egregious or flagrant, that they are subjecting residents to, quote, grievous harm, and that they are part of a, quote, pattern or practice of resistance to residents' constitutional or federal rights. So the CREPA covers things like a pattern of sexual abuse, neglect, unmet mental health needs, or inadequate education in facilities that host children. Was the situation in New York's public nursing homes abusive or grossly neglectful? That has yet to be determined. But in July, New York health authorities presented data allegedly showing that the coronavirus had infected nursing homes far earlier than once believed, and that, quote, readmitting residents that had been hospitalized for coronavirus did not contribute to a higher fatality rate in those facilities. But that's just one opinion given by Cuomo's own health authorities during the same month that he signed his book deal. The report compiled by Attorney General James saw things differently. James found, quote, a lack of compliance with infection control protocols, insufficient personal protective equipment, PPE, for nursing home staff, insufficient COVID-19 testing for residents and staff in the early stages of the pandemic, and a state reimbursement model for nursing homes that gave a, quote, financial incentive to owners of for-profit nursing homes to transfer funds to related parties, ultimately increasing their own profit instead of investing in higher levels of staffing and PPE. Cuomo claims that other states issued similar nursing home directives and are not being investigated. However, once again, that doesn't tell us anything about whether what New York did would be considered widespread abuse or neglect under the law. Although Cuomo hasn't resigned, he has lost the support of the Democratic Party in the state, which controls both houses of the state government, and the Senate Judiciary Committee has opened an impeachment inquiry. Now, that's a lot of scandals for one governor, and it's only been possible because whistleblowers have come forward. And if you have personal information that Andrew Cuomo may have broken the law, you should call authorities. And the best way to make that call is with Ting Mobile. It's good to see that the segues are still dark, even in 2020. But Ting Mobile is actually great. I personally switched to Ting Mobile. Why? Because of this. Yes, that is a real cell phone bill that I got with my previous provider, and it's why I personally switched to Ting. And Ting Mobile has 3 brand new plans to make sure that that never happens again. You can get talk and text for only $10 a month, data plans starting at $25 a month, and unlimited for $45 a month. Switching plans is actually really easy because you can keep your same phone number and use pretty much any phone. And the service is great too because Ting partners with several massive networks, probably the very same one that you're using right now, but at a huge discount. Now, contractually, I can't tell you which ones because I always respect contracts, but let's just say my service hasn't changed at all. Now, I had been on the phone with my previous provider for hours for the simplest things because I was always on hold. But with Ting, you can call them up and immediately talk to a real human being, or you can talk to them on chat, internet, Discord, you name it, they are available. And it's incredibly easy to transfer service to Ting by just simply ordering a Ting SIM card, popping it in, and setting it up. No phone calls required. It's like magic. And if you're around Wi-Fi all the time, like you're working from home, you have the flexibility to save hundreds of dollars a year. And Ting still gives you the option to just pay for what you use with their Flex plan. It's a smarter, cheaper version of the same plan that they've always had. And now they just give you the possibility of unlimited versions as well. So if you want unlimited, you can go absolutely crazy. So if you go to legaleagle.ting.com or click on the link in the description, you can use your last bill to compare just how much you would save. And Legal Eagles will also get a $25 credit that could cover 2 months of service. So just click on the link in the description and give it a try. Plus, clicking on that link really helps out this channel. So, do you agree with my analysis? Leave your objections in the comments, and check out this playlist over here with all of my other real law reviews where I talk about all the crazy stuff that's happening in the legal world. So, click on this playlist, or I'll see you in court.